pointed out, Senior Staff Attorney with ABA CILA.
And I'm Yasmin Yavar, also Senior Staff Attorney with ABA CILA. ABA CILA is the American Bar Association's Children Immigration Law Academy. We're a new program based out of Houston, serving attorneys throughout Texas who represent unaccompanied minors in immigration matters. Our mission is to serve as an expert legal resource center to enhance the quality of representation for immigrant children in Texas. CILA builds capacity for those seeking to advance the rights of immigrant children through trainings, technical assistance, and collaboration.
Okay, so we've all had a supervisor or colleague say to us that, hey, there's a practice advisory on that. You should read it. Only to respond, I don't have time. Just tell me what it says. Well, this is our attempt to tell you what it says, though it should not be a substitute for reviewing the original sources that we cite throughout. We're going to throw a lot of rules at you, and in almost every case, we'll try to boil things down to their essence and explain how they concern the everyday practice of representing unaccompanied children. We know you've all seen these rules before, but our goal is to frame them in the context of representing unaccompanied minors, which, as you all know, raises some very unique issues.
Our staff attorneys have all worked directly with unaccompanied minors, both detained and released, and although we cannot call ourselves experts on ethics, we understand the sensitive and difficult situations that arise throughout that process. With that in mind, we strive to approach our training from a practical point of view.
Okay, great. So here's our outline for today, and we're going to start with duty to communicate, talk about capacity of a minor, confidentiality, mandatory reporting, and conflicts of interest. There's a ton of material out there on these topics, and much of this is based on our own research tempered with our practical experience in representing unaccompanied minors. We'll have a bibliography at the end where you can find further guidance on any of these topics. Vera, the ABA, and AILA have all produced some very helpful materials on these issues. Before we jump into specifics, I want to make a preliminary point on the ethical rules that you're obligated to follow. We'll be citing the current ABA model rules of professional conduct and the Texas disciplinary rules of professional conduct throughout. Obviously, not all jurisdictions have adopted the model rules, and you should always consult the local rules in your jurisdiction. Here you can see that ABA Model Rule 8.5 talks about the idea that a lawyer may be subject to disciplinary authority of both this jurisdiction and another jurisdiction for the same conduct.
The Texas disciplinary rule of professional conduct on this point is at 8.05, and it's substantially similar. In short, you need to be familiar with the rules where you practice, as well as though you're licensed to practice, and do your best to comply.
And finally, there are further ethical rules that one must follow in practicing before EOIR or USCIS. And those there in the box at the bottom are from the Federal Rules of Practitioner Conduct and the Immigration Court Practice Manual at Chapter 10.4. So, duty to communicate. I'm going to move on here.
Okay, these are the rules that relate to communication. You have the ABA rule and its Texas counterpart. The ABA delineates a few more specific duties. You see only a few of them here. Why are these rules important? Because it's easy to communicate with the adults around the child rather than the child's client. But your duty is to keep your child client reasonably informed and explain matters to him or her directly. Some might argue that you actually have a heightened duty to communicate with the child client to allow him or her to make informed decisions about the objectives of the representation. To follow are a few reminders that can go a long way towards effective communication with your child client.
Here's some factors affecting communication with children. First off, they're not miniature adults. That's hard to understand sometimes, but age and education levels mean that their vocabulary is different, even if correct. So this is distinct from language abilities. This is when you're dealing with an American teenager in English, you're going to talk to them very differently from how you would an adult, right? So children are often deferential towards adults. They may agree just to please. And so you need to phrase things in multiple ways, even if they say that they understand. Ask open-ended questions to test comprehension rather than simply asking, do you understand? Again, you need to be reticent of too many yes answers. Educate yourself as the basic child development. Be sensitive to how the mind of an adolescent works. When you're talking about language, and dialects and legalese are noted here, you want to confirm they understand your Spanish. Just because you speak perfect Chilean Spanish does not mean that the Guatemalan child is going to understand what you're saying to them in Spanish. Again, you also want to confirm that that same child understands Spanish in the first place and doesn't understand or prefer their native indigenous language. You want to watch the legalese too, because there really isn't an equivalent in their legal system sometimes. So even if the child is fairly well educated and understands legalese, in their system it's going to be different from our common law system. When you can, put things in writing or draw a diagram that they can take home and reflect on later, when they're less overwhelmed. Explain the role of those involved in the child's case. For example, I'm your attorney, and I will go to court with you and speak for you before the judge. These are very basic things that you should not overlook in trying to get this across to the child as to what your role is. Cultural factors that go into it might be time and chronologies, both the actual time of day, they're going to be late for appointments, and also larger chronologies and timelines are difficult because they don't always think in our American sense of time. So this is both an age and a cultural factor. Finally, kinship terms. These are sometimes used interchangeably and liberally. Usage of things such as mom, tío, primo are used in various ways for different people. Sometimes madre does not actually mean mom and can be used for grandma or aunt. So what does this get us here? How does this all come together with unaccompanied children? Can they understand what's going on around them? How do you draw the line between attorney and the social worker/life coach that they may very well need? The odds are stacked against them in understanding the immigration process and stacked against us in explaining it to them properly. Yet, they're the boss. So back to our outline, we're going to move to discussing the capacity of a minor. What is your role as the attorney for a child? Should you secure removal for a child who states he wants to be removed, even if you believe it's in his best interest to pursue asylum in the U.S.? The ethical guidance on this issue is clear. You must represent the child's expressed wishes and abide by his or her decisions concerning the objectives of the representation. Even if your services were sought out by a family member of the child, it is the child who gets your loyalty. You see here the stated interest versus best interest, and there's some great language that comes out of the 2004 ABA standards. The attorney shall provide the child with legal advice and zealously advocate with the child's legal interests, as directed by the best wishes of the client. Also, the attorney must advocate for the child's expressed wishes or for his legal interests where the child expresses no wish. The rule underlying this point is ABA Model Rule 1.2. The lawyer shall abide by a client's decision concerning the objectives of representation. And here the child is the client.
The Texas Rule 1.02 is substantially similar. A lawyer shall abide by a client's decisions concerning the objectives and general methods of representation. Not much to add there, but what happens when a child client's decision-making abilities appear inadequate? In some of those cases, you might consider appointment of a guardian, ad litem, or a child advocate. What you should not do is substitute your own judgment for that of the child. Per the ABA standards on UAC representation, in the case of a child who fails to express her wishes for the representation or is found incompetent, the attorney must advocate for all legal interests, preserving any and all immigration remedies available to the child. Okay, now we're going to talk about the attorney-client relationship. When dealing with children who the rules treat as diminished in their capacity, the ABA rule indicates that the lawyer shall, as far as reasonably possible, maintain a normal client relationship. There is no Texas counterpart to the rule, so the comments to Rule 1.03, which is actually on communication, do discuss clients under disability, and they include children in this discussion. The comments indicate that the fact that a client suffers a disability does not diminish the desirability of treating the client with attention and respect, and discusses the duty to maintain reasonable communication with such clients insofar as possible. I think it's probably a good idea here, because these terms often get confused, to take a moment to distinguish between mental competency and child capacity. And this was really elaborated on in a very helpful practice advisory by Aria Summers from November 2014, done for Vera. Mental competency, as you'll see, is a legal construct tied to due process. And in matter of MAM, the BIA decision from 2010, they laid out the test for determining mental incompetency in the case of an unrepresented adult respondent. Now, you can definitely analyze kids' cases under that framework, but there are other considerations, additional considerations about children that can impact their due process rights distinctly. On the right side of the slide, you see we talk about child capacity. It's a broad concept that refers to an individual's ability to make a decision or perform a task in a given context, and children are presumed to have capacity. A child's capacity can be impacted by intellectual and cognitive disabilities. So some examples of that would be child brain injuries or birth defects, by mental health disorders, and also by child development. So the things that impact child decision-making, like normal brain development, much explored in the juvenile justice context, but not in ours. One takeaway for now, a child's capacity can be fluid. For example, a child may have the ability to articulate that they consent to your representation, but there may be other points in time when his or her capacity is called into question. If you have concerns about a particular client, you have a sense that something just isn't right, I encourage you to take a look at the materials prepared by Aria for Vera, cited here and in our bibliography.
Okay, so capacity to sign documents. That brings us to a common conundrum. Is there a bright line on age? And for the AILA practice advisory, no. You can make the determination on a case-by-case basis. It says right there, there's no minimum age regarding the child's ability to comprehend and sign an engagement letter. The lawyer must make a determination on a case-by-case basis. And depending on where you look, even within the immigration law and regulations, all kinds of numbers get thrown out. You can see there at the bottom that the INA defines a child as an unmarried person under 21, and in the federal regulations, a juvenile is defined as an alien under the age of 18, and later it uses minor when describing aliens under 14. So there's not a bright line age. What that gets us to is, can a minor sign a legal document? Yes. Everyone wonders about these agreements and contracts we have children sign at the beginning of a case. Really, what you call it doesn't matter. So what do they sign? It could be a retainer agreement, an engagement letter, a contract. It's a document meant to convey rights and responsibilities between two parties. Some suggest that it might be best to have no written agreement if the client is too young, but merely to explain the attorney-client relationship in such a way that the child understands the situation. I don't think that's going to fly for grant reporting purposes, but the question is whether the document has some legal effect. And yes, it would. Now, is the contract valid? For contracts, the general rule is that while it's not illegal to enter into a contract with a minor, the contract is voidable at the discretion of the minor. Voidable contracts are usually valid contracts and are binding unless the child cancels it. Now, this is largely academic since these are pro bono services we're dealing with in the case of unaccompanied minors. But that doesn't mean the attorney cannot enforce contract clauses. If the minor client is in violation of certain terms, most often something like failure to maintain communication, you can enforce the contract by withdrawing, which is a process we'll touch on later. But this is the difference between a child voiding the contract entirely, which ends your representation, and the attorney enforcing certain clauses and possibly withdrawing, which also ends the representation. Of course, if the unaccompanied child is over 18, the contract is entirely enforceable. So best practices for document signing. In the case of retainers or contracts, if the child is so young as to be incapable of signing, yet you are not seeking SIJ, obviously it makes sense to have the parent, guardian, sponsor sign for them since you'll be likely dealing with them primarily throughout the representation. But really, under 18, as it says here on SIJ, you want to have both the child and the sponsor or potential conservator sign your agreement. And under 18 for all other forms of relief, like asylum or a U visa or T visa, have the child sign if capable, otherwise the sponsor or parent, and over 18, of course, the client. With respect to USCIS, so your G28s, your I-360s, 485s, or 589s, those are likely your most commonly filed documents. And if the child is under 14, the child or the parent legal guardian may sign. If they're over 14, you definitely want the child to sign regardless. Bottom line is kids can sign. You do have the option in a pinch of having mom sign the G28 for you. Let's say you've already entered into representation and just forgot to get your G28 signed. Maybe you're at immigration court and the under 14 child's presence has been excused and the parent or sponsor appears for them. They could sign the G28 for you so you don't have to set up a separate appointment with the child just for that. I think it would be best practice in this situation to indicate signing as parent on behalf of or something to that effect just to avoid any confusion by USCIS. With respect to EOIR, there are not a lot of documents that the child would have to sign to present to EOIR, but as far as age goes, you do want to check the NTA if it was issued when the child was under 14. The rule on that point is the personal service rule required, and in the case of a minor under 14, service shall be made upon the person with whom the minor resides, whenever possible. Service shall also be made on a near relative, guardian, committee, or friend. That's at 8 CFR 103.8. So the point being with EOIR, you're not worried about what they're going to sign, but you do want to be aware of the age of the child in certain documents. Now, confidentiality. We've addressed some things to keep in mind with respect to capacity, so let's move to the confidentiality components. And confidentiality is really the intersection of the ethical rules, gaining client trust and rapport, and the IT security and file maintenance concerns. Some of the more, well, the rule on point here is ABA Model Rule 1.6a regarding confidentiality of information. And right there, it states plainly, a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out representation, or the disclosure is permitted under certain circumstances. So some of those more important exceptions to the ABA rule are that a lawyer may reveal the information if they reasonably believe necessary to prevent reasonably certain death or substantial bodily harm, to prevent the client from committing a crime or a fraud, and to secure legal advice about the lawyer's compliance with these very rules. Those are just a few of the several exceptions outlined in the rule itself.
And the Texas rule defines privileged and unprivileged client information and indicates that both are confidential. The exceptions for disclosure are outlined, and a few words noting are that a lawyer may reveal when there is express authorization of disclosure by the client in order to comply with a court order or the rules of professional conduct or to prevent the client from committing a criminal or fraudulent act. You should note that there's one non-discretionary reveal that you should be aware of in the Texas rules. It's located at Part E of Rule 1.05. It says you shall reveal when the crime is likely to result in death or substantial bodily harm. But back to the duty to keep information confidential. ABA Rule 1.6c provides as follows. A lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. And that brings us to our next slide.
Okay. So ABA model rule regarding non-lawyer staff. And this is important here. You can see that 5.3b states that a lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. And then you see that point at the bottom there coming from comment 2 of the same rule on training and supervision of staff. Lawyers generally employ assistants in their practice, including secretaries, investigators, law student interns, and paraprofessionals. Such assistants act for the lawyer and must be given appropriate instruction and supervision concerning the ethical aspects of their employment, particularly regarding the obligation not to disclose client information. So really how that looks in practice is that supervisors should have measures in place for the training and onboarding process to explain confidentiality obligations to all staff in the office. Also, all lawyers have an obligation to properly instruct their non-lawyer staff on said obligations as you go through your day-to-day practice. On the right here, I want to make a point on translators and interpreters. So you see right there the 2004 ABA standard lays out that the attorney shall ensure any interpreter or translator used in communications with the child understands their confidentiality obligations. And this is important. Many of you may speak Spanish, but there are others who need to rely on an interpreter for whatever reason, or maybe you're working with a pro bono who needs an interpreter when representing unaccompanied minors. This quote here at the bottom is important because oftentimes in those situations, people are tempted to use a family or a friend, someone who's sitting in the waiting room otherwise, that can just quickly interpret for you. Well, this quote here is taken from a New Hampshire bar opinion. The New Hampshire rule is also almost verbatim from the ABA model rule, and it lays out a really good point on the dangers of using family and friends as interpreters and how such interpreters may have a personal interest in the outcome of the representation, therefore it may be biased. It's a best practice in any of these situations to get any volunteers in the office, but especially interpreters and translators, to sign an agreement regarding that they understand their confidentiality obligation. So how do file maintenance and security measures factor into confidentiality? Here you can see on the left a desk that may look something like one of your own. Think about the way you handle client files as you go about the day and as you go through your practice. Organization of your desk is a client confidentiality issue. When you've got so many files stacked up and you've got various people in and out of your office all day, you want to take measures to lock up your physical files. You also want to think about the way your files are organized, as in which documents are located where in the file. This all comes from attorney work product considerations, which are delineated in the rules stated at the bottom there, and the Texas rules and the FRCP. Work product includes things like any material prepared, mental impressions developed, and communications made in anticipation of litigation. Now, this is generally thought of in the sense of protecting certain documents from discovery, and there's no formal discovery in most of what we do representing unaccompanied minors in an immigration court, but it is a good habit to be in and a best practice. Physical file setup, it comes about in where is your intake form located in the file. This has very sensitive information. You probably don't want it as the top document when you open up a file. You also want to be careful about what you write in the progress notes. This should not be used as interview notes or attorney notes. It's much more of a case tracking log. And as we just said, be sure to train your non-lawyer staff on these issues as well, how they keep and maintain the files and what they write in the progress notes. As we also mentioned, there are network and IT security concerns. You see here on the right that computers should be locked to a desk. Computers should be protected by security software like Symantec. And emails with client information should be encrypted. And so those come from not only your confidentiality obligations, they derive out of probably your grant agreements and contracts, but they really are part and parcel of this whole consideration. For the most part, they're more technical than I'm qualified to explain, but suffice it to say they're in place for good reasons, and it has to become part of our day-to-day practice. I know this means one more login or password that you have to remember and maybe type in when you're in a hurry, but we all have to be aware of these considerations. Additionally, we have to be aware of securing laptops and physical files when you take them out of the office. This means don't leave them in your car, basically. You don't want your car to get broken into and lose not only the expense of the computer, but also your client's information on top of it, more so. Okay. So, mandatory reporting, when and how.
Okay. So, the Texas Family Code requires as follows. A person having cause to believe that a child's physical or mental health or welfare has been adversely affected by abuse or neglect by any person shall immediately make a report as provided by this subchapter. That's broad language. It's any person, and they don't have to know something to be a fact. They just have to have cause to believe. The child doesn't have to be adversely affected now, so the abuse or neglect could have happened a long time ago. And it's not discretionary. The rule says shall immediately report. So what happens to your confidentiality obligations? Well, your attorney-client privilege often is superseded. Many states have mandatory reporting laws whereby an attorney's duty to report supersedes attorney-client privilege, and in Texas, the law specifically states the requirement to report under this section applies without exception to an individual whose personal communications may otherwise be privileged, including an attorney. The attorney-client privilege is only applicable in this situation to prevent an attorney from testifying against their client. So what does this mean for us in our UAC work? Abuse and neglect are defined in the same chapter of the Family Code. Should you be reporting in every case of abuse or neglect? Let's look at the definition. So abuse talks about mental or emotional injury resulting in an observable and material impairment. Talks about physical injury that results in substantial harm. Sexual conduct that's harmful to a child, failure to make a reasonable effort to prevent these things. And there are more. These are just some excerpts from the actual provisions in the code. Neglect encompasses traditional notions of abandonment. So the leaving of a situation in a child where they would be exposed to substantial risk of physical or mental harm without arranging for necessary care, demonstrating an intent not to return. And it's a reasonable person standard. So you really have to conduct a case-by-case analysis. You look at these definitions at 261.001 in the Texas Family Code. You need to ask yourself, based on these definitions, if the abuse has resulted in an observable and material impairment, if the physical injury resulted in substantial harm. Really conduct a detailed analysis. If you have a case that requires reporting, here's information on how to go about it in Texas. You can do so online, with the benefit that you'll have a written record of what you've disclosed. You might also decide to report by phone. And from what I've heard, the phone call report takes about 30 minutes. At CILA, we've never heard of a case where Texas DSPS has taken action on a report where the abuse took place in a foreign country and the abuser was not in Texas. That's not to say they won't, but it's a nod to the practicality of enforcement measures.
Okay. We've made it to our final topic, conflicts of interest, and there's a lot here. So I want to open with this fine slide and say that conflicts can come in many forms, and much of the literature out there does not specifically contemplate the most common scenarios that you're likely to encounter in representing unaccompanied minors. Luckily, we're not talking about the type of conflict here in this slide, but the first type we're thinking of would be a potential conflict across cases. This might look like a sponsor who wants to be a conservator in a child's custody case for SIJS. And should you be doing a conflicts check to make sure that your program hasn't identified the same sponsor as a negligent parent in relation to another child? That's one thing, one hypo we're going to work through on this. The second being, maybe your agency previously did a family petition on behalf of a USC father, and he later becomes an abuser. Can you then represent the victim for a VAWA petition implicating that former client? So the definition of conflicts comes out of the Model Rule 1.7, and here we're looking at overall traditional program-wide pre-acceptance conflicts checks against other clients. And 1.7a right there lays it out that a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. Now, what does that mean? It means that the client's interests are directly adverse to another client, and that there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client. So in the first typo, it kind of implicates Rule 1.7, and the rule, as I just stated, is laid out with directly adverse interests. So our hypo, a sponsor who wants to be a conservator in SIJS, does your program represent them if the same sponsor is a negligent parent in relation to another child? Well, I think this is exactly the sort of directly adverse scenario that the rule contemplates. And the second hypo was getting more at duties to former clients. So the rule there is going to be 1.9, and as it lays out, if you have formally represented a client in a matter, the lawyer shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client. So there's a lot of legalese there to be parsed out. The second hypo implicates these duties. Now, our hypo was that your agency previously did a family petition on behalf of the USC's father. He later becomes an abuser. Can you then represent the victim for a VAWA petition implicating that former client? This scenario is somewhat removed from direct rep of an unaccompanied minor, but you would certainly want to run a conflicts check and be able to determine whether this would qualify as the same or substantially related matter, and whether any confidential information you gain from the former client would come into play here, as it also covers, and in comment 3 talks about confidential information that was gained from that former representation. So you just have to, in every case, know if there might be a conflict of interest by doing a conflicts check at the beginning, and then determine, based on the facts at hand, whether a true conflict exists and whether you can go forward.
And the Texas rules on point are at 1.06 and 1.09 respectively, and they're the next slide. They're really similar to the ABA rules, and you'll just see the reference in Texas Rule 1.09 to Rule 1.05, which is the rule on confidentiality. So they really want you to be aware of whether the representation in reasonable probability will involve a violation of your confidentiality when you're dealing with representation that might be adverse to a former client.
Okay, so consent despite a conflict. And the same rule, 1.7, is in play here. Part A is what we just mentioned previously, and Part B gets at the second part of it. It kicks in when there's a conflict, but you get consent to proceed anyways. There very well may be no conflict at the outset that would trigger 1.7b, but because there's a potential for conflicts to arise, it's probably best practice to inform your clients fully about the types of conflicts that might arise. Comments 18 and 19 to this rule make it clear that where there's actually a conflict, you must discuss with potential joint clients the implications of the common representation, including possible effects on loyalty, confidentiality, and the attorney-client privilege, and the advantages and risks involved. Note that in most U.S. jurisdictions, the attorney-client privilege is interpreted so that there are no secrets between joint clients, so that a lawyer may share with either client information provided confidentially by the other client, though the privilege remains intact as to the rest of the world. And that's going to come up later in one of our hypos that we discussed.
Okay. So the Texas disciplinary rule on this is 1.06c. A lawyer may represent a client where there's a conflict if the lawyer reasonably believes the representation of each client will not be materially affected, and each affected or potentially affected client consents to such representation after full disclosure of the existence, nature, implications, and possible adverse consequences of the common representation and the advantages, if any. So, again, this is a situation where there is a conflict, but you proceed with the representation anyway. In practice, many of us in Texas have used what's referenced in the rule, these informed written consents. And the ABA rule required that if in writing, the Texas rule doesn't. But we've used these in SIJ cases where we're offering dual representation, not because there is an existing concurrent conflict necessarily, but we're sort of on the lookout for potential conflicts that may arise in the future. We're representing the child in his or her immigration case, but representing some adult in their life to obtain a state court predicate order. So the next slide is a sample dual representation letter that you might consider utilizing to offer full disclosure to joint clients.
Okay, and this question was actually just asked in the Q&A portion there about a sample kind of form in this regard. And we'll also touch on a sample, maybe informed consent form, or how that might look. But here's a sample dual representation agreement, and we're going to walk through certain sections and why they're there. Obviously, you want this document in Spanish for your clients to sign, and you may want to only use the Spanish version in your file. You can always translate it later if need be, but here we're going to walk through the English. So the first section, you want to make it clear, obviously, who the form is directed at, and here we're looking, to just make, yes, you've got your dual rep, and you lay it out at the top as petitioner, you lay one out as child, you do the same in the signature lines at the bottom, and this is just so you make sure you have each of them signing these things. The second portion is important to clearly delineate the scope of the representation. Moreover, this also serves to succinctly advise both co-clients on the full immigration implications of SIJS. While you may or should have at least already expressed the idea of no parental petitions via SIJ to the child, it's important to note it to the sponsor or potential conservator as well to preclude any notions they might have of gaining some immigration benefit by agreeing to this course of action. And so again, you know, you lay it out here, you're going to want to explain it as well orally as you're going through this.
Okay, this next paragraph goes to disclosure of the nature, implications, and possible adverse consequences that are cited in the rules. Again, none of this is required unless there's an actual conflict, but certainly it is not a bad idea. So this talks about, we've advised you that should a conflict arise between you and the child, we may be required to withdraw from both of your cases, one or both cases really, and that may affect your state court proceeding or the child's immigration proceedings. We may have to withdraw in situations including but not limited to the abuse or neglect of the child by you or another person.
Okay. And here, this is really a best practice portion. You want to describe the benefits and right to consult independent counsel. And this comes from comment 19 to the ABA rules, where in some cases, the alternative to common representation can be that each party may have to obtain separate representation with the possibility of incurring additional costs. These costs, along with the benefits of securing separate representation, are factors that may be considered by the affected client in determining whether common representation is in the client's interest. So again, this isn't going to handle every possible aspect, but you want to just at least touch on the major points here and make sure you're giving them time and the knowledge that they have the right to go seek outside counsel and what the benefits of doing this joint representation might be. And then we have another section here. This bottom piece is going to be legalese. We just talked about how a child, even if they say they acknowledge and have read, this would be avoidable by them. Definitely important to get the petitioner's signature, but it's important to get the child's signature too, just to have buy-in in the case and to keep them on board. And then, again, if possible, at the end of all this, and really at the beginning, I guess, you want to try to explain this document in separate one-on-one meetings with these clients. Now, I know that's not necessarily possible in your day-to-day practice. There's time constraints, and it's often way easier to explain it just once to both. But you really, to be able to give them proper counsel on this issue, want to try, if at all possible, to explain this in a separate meeting with each. Okay.
Okay, fine. Let's talk now about when conflicts arise. Conflicts may arise in our dual representation SIJ cases. Sometimes there's no per se conflict under the rules. The adult and child simply want different things. So let's talk about some examples. Here's some scenarios we've seen in practice. A child no longer wants the potential conservator to have rights over him or her. My aunt's too strict, they're telling you. I don't get along with her boyfriend. I prefer to live with someone else. These facts develop after you've already entered into the dual representation. Second bullet, the proposed conservator no longer wants to be responsible for the child. So that's where they're telling you, my circumstances have changed, I can't handle any more than what I have, the child won't follow my rules, the child's getting into trouble. The third bullet, the proposed conservator abuses or fails to report abuse by another of the child, and maybe it's a situation there where you're actually contemplating mandatory reporting. And then that fourth bullet, the conservator confides that the father on the birth certificate is not actually the father, but they want you to keep it a secret. It's a secret. In that situation, you're thinking, can you convince the parent the child has a right to know and that you can't go forward knowing you have a false birth certificate? Can you make them talk it out, basically? So what do you do in each of these scenarios? Well, you really have to look at the relevant rules, and in Texas, those are 1.09 and 1.05, and figure out whether there is a conflict and whether you need to withdraw from representing one or both clients, and then simply proceed. Think about whether there are really adverse interests, and I think in that third example, that would be probably the clearest example of adverse interest, or whether there's simply different interests, like those first two bullets, right? In those first two situations, you might consider withdrawing, or you might need to withdraw, not because of a conflict that's arisen, but just as a practical matter, because you're not going to seek conservatorship, custody with that same adult. Rule 1.15c is where you're going to look as far as how to withdraw. So a lawyer shall take steps to the extent reasonably practicable to protect a client's interests when they're withdrawing.
Okay, so appropriate withdrawal. The Immigration Court Practice Manual at Rule 2.3, motion for withdrawal of counsel, says that it must include the reason for withdrawal of counsel in conformance with applicable state bar or other ethical rules. So our ethical rules here, we're going to cite to the ABA model rule 1.16b, and a lawyer may withdraw from representing a client if withdrawal can be accomplished without material adverse effect on the interests of the client. And then also, you see we skip to Part 5 there. If the client fails substantially to fulfill an obligation to the lawyer regarding the lawyer's services and has been given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. So those are just two, the most pertinent parts of this rule that we picked out here. And I have a couple scenarios here at the bottom. You can see the Texas rule is similar in this regard. But scenarios at the bottom are, one, withdrawing an immigration court when your client doesn't show up or is simply MIA. First off, you don't have to withdraw, but if it's necessary, so if you truly don't know where they're at or they've even told you that they're no longer going to show up to court, you'll want to ask for a continuance for them. And this is, again, to protect their interests. You want to ask for this continuance in order for them to have time to seek new counsel. If the judge says they'll hold the in absentia until that afternoon, which at least here in Houston they're likely to do, you can call and leave a message with the client, of course, the last known number you have for them, telling them as much. And I've even gone so far as to leave a note with the clerk at the front of the court saying that client X might be coming in later that day, and please direct them to Judge Y. The big thing is you want to document all of this in your case file as well. So you're going to want to sit down almost immediately, write in your progress notes, that you had to withdraw, but that you also motioned for continuance, that you called them immediately, that you took all of these steps. And I presume, of course, that you've called them several times before that point. So you want to document that as you're going through. Another common scenario might be withdrawing via letter when they don't show up for office appointments and you can't get a hold of them. This happens a lot in immigration law, especially with unaccompanied minors. And what do you want to do there? Well, you want to send no contact letters. You want to have a letter written up that says you failed to show for this appointment, or we cannot get a hold of you at the message at the number that you've left. And as for maybe a clause in your contract, it says you are obligated to maintain contact with us. So you want to send this no contact letter, and you want to have a specific deadline in there. You want to say, please contact me by, and put a date maybe 2 weeks out or 3 weeks out. So there's something hard and fast for them to work off of. If you still don't get a response, you'll want to send a final letter notifying of imminent withdrawal. You did not respond to our last letter. We are going to file a motion to withdraw if you don't respond again by X day. If X day rolls around, that's when you would file your motion to withdraw with the court. And, of course, you'd serve a copy of that on their last known address. And then you want to, again, send the final granted order to that address as well once you get it. So all these steps you need to take to make withdrawal appropriate throughout the process.
Okay, so now we're going to do a quick review of everything that we've gone over and then hopefully answer some questions. So remember, know the rules where you practice and where you're licensed, if those are different, and both may apply to you.
You have a duty to communicate with your child client. Work hard to explain things well and elicit your child client's story and best wishes.
Abide by your child client's stated interests and strive for a normal attorney-client relationship to the extent possible. Your agreements with him or her may indeed be voidable, but the key is ensuring he or she understands the scope in terms of representation, what you expect, and what he or she can expect from you.
Confidentiality is king. Respect it as you would the confidentiality of a sophisticated adult client, and be sure to teach your non-lawyer staff the same.
Know the rules and procedures for mandatory reporting, and remember that where it is implicated, confidentiality gets thrown out the window for the protection of the child.
And finally, check for conflicts, and as a best practice, inform your joint clients of the potential for conflicts. Although this is not required by the conflict rules unless an actual conflict exists, obtaining your joint client's informed consent may be a good idea. So we have our sources here at the end, but they're at the top for those of you in Texas.
Yeah, here's the number to the Texas Ethics Hotline operated by the State Bar. They can be incredibly helpful as they know the rules inside and out and are very well versed in ethics opinions that are issued here. For those of you outside of Texas, your bar likely has something similar. And remember that when you're trying to figure out how to comply with the rules of professional conduct, you can talk to them about your cases.
Yeah, and so here are some of the sources that we relied upon in putting this presentation together. As I said at the outset, there probably is a practice advisory on just about every scenario you can come up with, but the hard part is reading through them all and distilling it down to an answer for your specific question and case. Feel free to write to us if you want to read more about a particular issue, and we can direct you to the resources on point that are available. Okay. And before we take questions, we're just going to leave you here with our information. Here's our contact info. You can contact me or Yasmin directly. Know that we're here to help you, and we'd also love to hear your feedback on this webinar or ideas for future trainings. We don't have all the answers, but we're happy to research the issues of concern, whether it be a broad issue or an individual case matter in the form of technical assistance.
For those of you in Texas, we're finalizing the agenda for our first day-long CLE here at South Texas College of Law that will take place on April 1st. We'll be sending out registration information for that very soon. And our next webinar is scheduled for April 22nd. Give us a few weeks and we'll get you details on that as well.
So if you have any questions, and we do have a few from the Q&A section down here, we can try to get to those now. And of course, if you have other questions, we can follow up offline with you if you want to send us an email.
Okay, so one of the questions that was written in was a situation where a child, there was one retainer agreement signed with the child and the child's sister, and they were both listed as clients for a SAPSER. So for those of you outside of Texas, a SAPSER is basically our custody petition. And the child was the client for immigration court and SIJS. So the SAPSER order was obtained, but now the child actually wants voluntary departure. The sister, who I think we're presuming was appointed the conservator in the custody suit, wants the child to stay. So I think you're okay here because the sister, your representation of the sister has been completed. You did what you set out to do. You obtained the custody order that she wanted, and you need to really listen to the wishes of the child. And we can go back to that slide just to look at it. But they're two separate cases, and at this point you're only representing the child, and you need to comply with her wishes.
The expressed interest of the child, the slide you want to see?
Yeah, sorry. Give us a second.
Okay, we're almost there.
There it is, right? So now you're advocating, you've concluded representation of the sister conservator, basically. That would be my take on it.
Yes. And the voluntary departure piece actually brings up another issue that I wanted to touch on, in that we were talking about explaining things to child client, and this is one of the more difficult scenarios to explain to a child client. We talked about how teenagers are more likely to maybe take risks and think differently from how we think, and that's one of the hardest pieces in describing a 10-year bar to a teenager, because 10 years might as well be an eternity. And so that's one that you really have to go above and beyond and really lay out carefully when you're describing the advantages and disadvantages of voluntary departure so that your client is fully informed when they make that decision. Because again, children clients are going to think 10 years is an eternity, and that 10-year bar might as well be a lifetime bar. So you need to really lay it out to them. I don't know, did we see other questions here? Let's see what we got. Okay. a copy of the sample informed consent for dual reps. So yeah, please email us, Elian, for the, we can give you that sample form, and we'll also have this presentation posted that you can pull off of there as well.
Yeah, and as far as the sample consent, we can obviously provide it in Spanish because that may be more useful for you all, in both languages, actually.
Okay, and here's a great question. When you're representing two siblings for both the SAPSR and SIJS proceedings, should you have them sign separate retainer agreements?
Yes, I think that that would be a good idea. They're each your client. They each need to know what you expect of them and what they can expect of you. They're separate clients, even though you're representing them both in related matters. So I would say, yes, you want separate retainer agreements.
Yeah. Okay.
Okay, we've got a follow-up comment. We want to make sure that pursuing voluntary departure for a child subject of a SAPSR is not materially adverse to the sister's conservator's interest as a former client. That's a good question, and I don't know if we can answer that off the top of our head. I see your point. I think that if you're not continuing to represent the sister in any way and that representation has ended, it might not be materially adverse, but I think we'll have to look into that further, honestly. We'll get back to you, Ashley.
Okay, any other questions? Vera, I believe, is going to be posting this on Extra Legal, and will be able to explain more about where you can follow up to see this webinar again. And we do have some time left, so if you'd like to write a question in the Q&A box, we'd be happy to try to answer it. What's the process for getting a child advocate or guardian ad litem appointed? That's going to depend on what state you're in. So are you in Texas? California. Yeah, in California, that's going to be very specific to the California rules, and none of us here are barred in California to speak to that, really.
Are you talking about for the person writing in from California, are you talking about an immigration case, or you're talking about an EOIR?
Okay, okay.
So that's the type of situation where you might want to get the Young Center involved. I don't know if you're familiar with them, but they're actually down the hall from us, and so we can connect you with them. But the Young Center actually specializes in that type of work.
Hi,
yeah.
Yasmin, this is Will. I will just add in, Vera will be having a bi-monthly call that we're going to announce soon, and it will be next month on March 18th, and it will be a presentation by the Young Center that will explain the child advocate services that they provide in more detail and how to make a referral to them. So I would hold off for then.
Great, thank you, Will. We got another question about how you address mental competency in front of an asylum officer at an interview. So I think that you would have to bring in some sort of expert report that analyzes the child's competency issues so that you can make the officer aware of the limitations on their ability really with respect to the interview.
Yes, and there's also some BIA and circuit case law on general mental competency issues when an adjudicator, an asylum adjudicator, is assessing an asylee's case.
And you might need to bring in that situation an adult in the child's life that has maybe been a witness to some of what the child has suffered to be able to give the testimony that the asylum officer is looking for.
Yes, and that's the kind of thing we can help look up for you via some technical assistance if you need further follow-up on the case specifically. Okay.
Yeah, feel free to write us if you want something in particular. We're getting requests on the mandatory reporting, and we'll follow up offline. I think there was one more. Okay, I have for dual representation cases. Sorry, can sorry, I'm trying to read this. Can I prepare an affidavit for the child if I'm representing the guardian in family court, presuming that the child is not yet represented by another attorney? I'm not sure if I'm seeing the issue, Elian, with that question. I guess you're preparing an affidavit for the child to be filed in family court. Yeah, I don't see any adversity there, and I think you'd be able to do that. And in practice, I've actually done it myself. So if we have any more questions. Okay. We have a question, is there a way to access the presentation if you're not here? Yes, we can send it to you. So if you don't mind just sending us your email address, we can send you the PowerPoint. Okay.
Okay, I think that's about it for questions coming in. So anything else, please, as we said, feel free to send us a message offline, send us an email, or call us, and we'll be happy to follow up either over broad circumstances that we touched on today or even individual cases by a technical assistant. Thank you so much for your time.
Thank you. Happy Friday, and thank you, Will, for helping us.
Okay, no problem. Thank you, everyone.